Dr. Wilfred Mutubwa is the Chartered Arbitrator and Chairman of the Chartered Institute of Arbitrators of Kenya branch. And he's here because we want to talk about promoting Nairobi as a preferred seat for international arbitration. We want to welcome him in the studio the way we welcome our guests with the day's Proverbs. We've been doing Proverbs for Malawi the last 4 days. Today, we switch it up a little bit because we had a guest earlier from Igbo, Nigeria.
Half Kisi, half Igbo.
Yeah, half Kisi, half Igbo. So it's an Igbo proverb. Character is like pregnancy. You cannot hide it. Character is like pregnancy. You cannot hide it. Dr. Mutubwa, good morning.
Good morning, Eric. Thank you very much for having me here today.
Karibu sana to the hot seat of the Situation Room.
Nashukuru sana.
That proverb, do you see where they're coming from? The Igbo people. Character is like pregnancy. You cannot hide it.
Absolutely, absolutely. In the profession which we practice, arbitration, integrity, character, consistency, competence is important. And we often remind people we train and the people we set out to resolve disputes out there that at the end of the day, it is your character, your integrity, your personal competence that stands out.
Yeah.
So with time, even if you are able to hide some of that inability, it comes out. So the proverb is actually very apt for this discussion.
Very good.
Yes.
We have had conversations about arbitration several times before, and looking at various ways in which disputes are resolved, and arbitration is one of them. But we have not held a conversation about the Chartered Institute of Arbitrators, Kenya chapter.
Yes.
We've talked about the Nairobi Center for International Arbitration. Are those two, competing units? Do they work complementarily? What's the difference?
Thank you very much. Eric, I like reminding people that the Chartered Institute of Arbitrators is a global body. This is the leader in dispute resolution, alternative dispute resolution, and arbitration, particularly arbitration, mediation, and construction adjudication. The Nairobi Center for International Arbitration is our baby. We are 40 years in this country. The Chartered Institute is 105 years old. Established in the UK, in over now 100 countries, 17,000 members strong. So we have the Kenya branch, which I am privileged to lead as chairman. We set up the Nairobi International Arbitration Center about, this is going to now 10 years, to 2013, by an act of parliament. So it's a local organization set up by statute.
Okay.
We supplied the first set of arbitrators to them. We train arbitrators for them. They accredit arbitrators whom we have trained. We are the leaders in training. I am one of the members of the Nairobi Center for International Arbitration. And we are related. We are not competitors. We synergize our efforts. In this space, we do not see ourselves as competitors. We are actually partners. We run very many activities together because our goals, our objectives, our target market is the same. So when you look at what we do the same thing. We promote dispute resolution away from court. We train arbitrators, mediators, and adjudicators, and therefore our roles are really complementary, more than they are actually competitive. So we are not competitors, we are partners, we are people who operate in the same space.
Does the Institute also license arbitrators in this country?
The Institute does three things. The first thing it does is to train the arbitrator.
Yeah.
Eric, if you want to become an arbitrator, you join us. We offer you courses right from the elementary stage to the very highest stage. Then we accredit you or register you or license you to practice arbitration globally. You don't just practice domestically. Then number 3, we promote ADR and its practices in various ways. We have conferences, we have discussions like these, we prepare materials, we also engage government and non-government actors, private sector, commercial actors, so that we promote the practice of alternative dispute resolution, particularly the resolution of disputes through private processes such as arbitration.
Right.
So yes, that is our mandate.
those who serve or those who practice as arbitrators,
Yes.
are they full-time arbitrators or do they find themselves doing other things?
As I have said, we are now 40 years in this country. We have 1,200 members. We began by many people practicing arbitration as a secondary profession. I'm also an advocate of the High Court of Kenya. I am also a law lecturer. So many people have other professions. But increasingly, we are beginning to see that the market is growing large enough to accommodate people who have full-time arbitration practices. So we have people who are now full-time arbitrators, full-time mediators. We now have the court annexed mediation process, as you may know. And we have accredited, and I serve on the task force appointed by the Chief Justice to roll out this process across the country. What we have noticed is that there is now a new profession of alternative dispute resolution practitioners, full-time practitioners who are able to sustain their livelihoods by practicing arbitration and mediation. So yes, it is something that the market is now accepting. Yes.
What would you say the load is like? Manageable, or are there cases that come in on a regular that would then say the centers are, they're busy?
Okay. I will give you some comparatives because that is how you can be able to see the perspective. One of the oldest institutions managing arbitrations or administering arbitrations in the world is the London Court of International Arbitration. I am a member. Administers about 400 disputes a year. Remember, this is right at the center of the commercial dispute resolution in the world, London. That is where it all happens in arbitration. They do 400 disputes a year. The Chartered Institute of Arbitrators, Kenya branch, not the entire global charity that is a chartered institute, the Kenya branch alone now appoints arbitrators in about 300 disputes every year. 300 disputes. And I forecast that in the next 5 years we'll be doing about 1,000 disputes. We are only 40 years
All
here.
local.
All domestic arbitrations.
Wow.
Now, it tells you how Kenyans have accepted, particularly people in the legal profession, the construction and commercial spaces. That is where we are really active. And yes, to answer your question, the load is growing. When I joined this institute about 13 years ago, the institute was making 20 appointments a year. Today, we are making 300 in 13 years. Another 10 years, you'll be talking about 2,000.
Yeah.
Yes. Yes.
Who is bringing these cases? What is the nature of cases that then come before the centers? Who has issues? I mean, obviously, seeing alternate, dispute resolution, that clearly, because otherwise the court already is mashed up. There's not, in terms of space for cases, backlog is crazy. So obviously it's an alternate form. We know that and widely accepted. But what is the nature of the cases? Who is coming before the centers to have their cases sorted out?
Now remember, arbitration is a creature of agreement, consent. People must agree to go away from court. We say you contract away from court. So you say you're going to resolve your disputes by way of a private process before a private judge, so to speak. So the people who come to us, our clients really are commercial people.
Okay.
I receive requests from many organizations. International commercial people do not trust domestic courts. That's just how it is across the globe. People interacting at an international level. You see, if you have a businessman, an investor who wants to come to Kenya or go to Rwanda, and he is from Israel or is from France, he understands French law or Israeli law. He is not quite comfortable dealing with domestic judges and courts. But he is very comfortable having an international arbitration center manage a dispute in the event it arises. So most disputes arise out of commercial relationships. I have received requests from virtually every sector, the energy sector, media. I have received requests for appointing arbitrators from the Standard Group, other media houses. So every commercial transaction usually has an agreement, a contract, with an arbitration clause. Statistics will tell you that out of every 10 contracts, 8 have an arbitration clause. An arbitration agreement is there. In Kenya, out of every 10 conveyancing agreements, sale and purchase of land property, 9 have an arbitration clause. And out of those 9, 7 will nominate or identify the Chartered Institute of Arbitrators as the appointing authority. So it is really a process of resolving disputes, particularly commercial disputes. Very popular with commercial disputes. Arbitration has been around for about 700 years.
Yeah.
It grew out of the need to resolve cross-border disputes, particularly commercial disputes.
Yeah.
So it's a method that is embraced by commercial people. Yes.
With mediation, where we see that, sure, you
Yes.
have court-appointed mediation, and then even after the process, the results of the process must still be lodged in court.
Yes.
There must be a mention and to say, okay, yes, we have or we have not, been
Settled.
through the process.
Yes.
Does the same thing happen with arbitration? Must you then still go to the court and say, this has been finished, or are you independent
All right.
in that manner?
There are two ways to see it. The arbitrator is a private judge, as I said,
Yeah.
and he renders a decision. And this decision is enforceable by law. In Kenya, under the Arbitration Act, most arbitral awards are actually taken up and enforced or accepted without enforcement. In fact, the sorry for this.
Amekuona kwa TV.
The statistics which we have show that actually about 70 to 80% of awards are taken up voluntarily. Now, a small percentage have to go to court because the nature of people is that some people do not agree with the decisions of the arbitrator. Some arbitral decisions are subject to challenge. You may go to set aside for one reason or another. Assuming, Eric, for instance, you had an arbitration,
Yeah.
and an arbitration has proceeded without your knowledge. You only come to know about it at the end. You must have some recourse.
Of course.
Secondly, enforcement by use of court helps you to get the sanction, the ability to enforce it. Courts have the power of state,
Yeah.
the authority of state that comes, the ability to appoint bailiffs and auctioneers to enforce awards. Now, private judges do not have the same facilities or access to state authority or instruments such as those. So in very few circumstances, matters have to go to court for enforcement or for reconsideration. So that is the balancing act, the balance that is struck by the act in ensuring that there is fairness in the process itself. Remember, it's also a legal process.
Yeah.
Yes.
Does the Arbitration Act stipulate that both parties, because it follows that there's a contract,
Yes.
and the contract has an arbitration clause.
Absolutely.
All right.
Yes.
And the contract may stipulate how the arbitrator shall be appointed.
Yes.
That the two parties shall, if the contract says that the body for arbitration shall be the Chartered Institute for Arbitrators, then that is what we shall use.
Yes.
Now, is it possible that arbitration begins and proceeds without one of the parties' knowledge? The example that you've just given.
Now, the heart and soul of arbitration is consent, agreement, as you have put it. Either an agreement beforehand, when you're signing an agreement to buy a house, to purchase property, to buy seats. That is where you have the arbitral agreement or the arbitral clause. Now, you then have a situation where the dispute arises.
Yeah.
When the dispute arises, one party can commence the process of arbitration by sending notice to the other. If the other party does not respond, depending on how you framed your arbitration clause, you may proceed just the way you proceed in court ex parte. But notice must be given to the other side. All that is required in the act is that you are given an opportunity to take up defense or respond. It is your choice whether you decide to come on board or not. But arbitration cannot proceed on the basis of a unilateral process.
Okay.
You cannot just say, now I've chosen you as the arbitrator, we are proceeding without Andu knowing about it, and yet you have a contract with her. What is required is that you must give notice and you must give her an opportunity. The rules of natural justice apply. One must be given an opportunity to be heard. Every judicial process, including arbitration, has certain basic principles, including the right to be heard and the right to be heard by an impartial arbiter a person who has no conflict or interest in the matter.
Yeah.
Yes.
Who appoints arbitrators to cases? Do you choose, or is there or does the centre now say, okay, this case has come before us,
Yes.
this is who we're going to appoint? And can parties have a say? You know, kind of like how you
You're given a panel of
you
five.
given a panel, or like
Okay.
how in the jury system you pull a jury, for example. Does it
right.
happen kind of the same way?
It's a very simple process, by the way. The principle that underlies arbitration is called party autonomy. The principal difference between court and arbitration is that you have an ability to choose your own dispute resolver.
Okay.
You're neutral, the person who will resolve the dispute. So that is a unique character of arbitration. So how does it work? You write to the other party and say, look, I am in dispute with you and we want to appoint an arbitrator. Depending on how your clause is structured, the first opportunity is given to the parties to agree to an arbitrator. So you can say, we want to appoint X as an arbitrator. The other party will say, no, I am suggesting Y. Then we both say, X and Y, we can't go with X and Y, we will go with Z. That is one of the ways. When the matter now comes to us, what we do is that we look at three things. We look at the nature of the dispute. Is it a dispute regarding the sale and purchase of gold, minerals? Is it a dispute in defamation in a media context? And therefore, who would be the suitable arbitrator in that situation? We maintain a register of arbitrators. Now, the other quality of arbitration is that it employs expert knowledge. Eric, if you decide today to take up arbitration as your secondary profession, and I want to invite you to join us, it's a very short course, very easy to learn. If
With-
we have
with
a
good
dispute,
money.
it has. You are paid an hourly rate, and it's an hourly rate from a very low rate to the very highest, depending on your experience.
Okay.
So when it comes to us and we have identified that it's a dispute in, for instance, regarding some arrangements in the media, we look at about people within the media, people with primary training in media. And then we look at the experience. And then we look at the subject matter, how much is being sought. Then we appoint an appropriate arbitrator who fits those the criteria that has been set out. And then we appoint that person. That is how we do it. But the first opportunity is given to the parties themselves to try and appoint. If the
someone.
parties asked us to give them a list, we give them. But we maintain a register of licensed people or members who are in good standing. I hope that answers your question.
It does.
Yes.
I'm looking at, again, to look at how I want to use justice is served. How long is there an average, or does it depend on the nature of the case? How long does it take for cases to be then resolved? Is there a time set and say, look, I think now we are
You
seeing
must
that
start
in the
and finish
justice system,
within.
All right.
Yeah, some of the tribunals that we see, you must start and be finished within 60 days. I think that is the norm that we are seeing coming out of the courts and the tribunals today. Do you have the same thing, or look, let the case live out its life? When it's done, it's done.
One of the reasons why parties come to arbitration or choose arbitration, particularly commercial people, is because of the expeditious disposal of disputes. They expect that disputes will be resolved expeditiously. The act that governs arbitration in Kenya does not set a time frame. But generally, arbitrations take between 6 months and 2 years. And for you to understand that that is a short period, compare these with court. The average period taken for a court case to travel the entire distance from magistracy to the Supreme Court or to the Court of Appeal in Kenya has been estimated as an average of 12 years. If you file a case today, you are likely to conclude it in 12 years. If you are contesting your retrenchment from employment, you are most likely to have retired even before that issue is resolved.
Yeah.
If you look at 6 months to 12 to 2 years, it makes sense. The second attribute that makes it even more attractive is that an arbitral award, the arbitrator's decision, is final on the merits. You can only question the process if the process was not properly followed. But on the merits, if there is a finding that Eric is owed 2 million shillings, and the evidence laid is in this manner, you are unlikely to challenge that merit finding, and therefore it gives commercial people two important characteristics. The first one is that they have finality, and number two, that the finality is quick, within a reasonable period. Of course, there are some disputes which take a shorter time and others slightly more time, but the average period is between 6 months and 2 years. Yes.
I want to come back and ask you about this number of cases that are being handled in Kenya. But before we do that, let's take a break.
This is the Situation Room, the only way to start your day.
Eric Latif Ndu Oko and our guest for this hour, Dr. Wilfred Mutubwa, Chairman of the Chartered Institute of Arbitrators, Kenya branch. Dr. I want to go into what you said earlier. You give the comparison of how busy the arbitration sector is in Kenya, and you compare it with London. You said this is like the seat of international arbitration. 400 cases being handled in London in a year. 300 cases being handled in Kenya in a year. What does that say about Kenya? Is that where we are too litigious? We have too many disputes?
I like looking at it this way. It tells you that Kenyans believe in resolving disputes through peaceful means. Disputes will always be there. How you choose to resolve them then determines what kind of society you are.
The character
of the society. So the character of this society is that as much as we are litigious, we know that we have options and we understand that we have possibilities. We have approaches away from court. So I look at Kenya and its growth in terms of the arbitration space. The mediation is actually doing very well. I know that we have almost a 99% acceptance of mediation in court today, because the matters which are being referred to mediation are either being resolved or are ending with partial settlements. But the point I'm making is that, look, Kenyans have realized that a perfect society does not exist. Disputes will always arise between commercial people, between people in employment and those who are doing business, but we will always resolve our disputes in an amicable, peaceful manner. The alternative is something you do not even want to consider or conceive. So that when I look at the growth of arbitration in this country, I see a strong sense of belief in our domestic systems. I see a strong support for alternative justice systems by government, by private sector, by commercial people, by all stakeholders. And now, including by the media now, because this is where we get to interact with the people who use these services.
I buy that. I see the way you've given it. That context is good. It shows that we're a people who want to resolve disputes. We want to have amicable resolution of issues. But I also see the other side. It's like every time people are getting into a contract, into an engagement, there's insufficient goodwill. There lacks 100% or at least 90% of goodwill, such that a matter is likely to end up in dispute.
Other than not.
Yes. It's like the higher likelihood, as we start this conversation, there's going to be a dispute somewhere. We've put it on contract. We are saying this is how we're going to operate. This is what we're going to do. But it's like we are not starting from a point of goodwill.
You see, when you enter into a dispute, the time when you sign a contract, when you're happy, when you're getting employed, when you're getting that job, that is the time to include a dispute resolution clause when people are happy. Because they say, if it can happen, it will happen. And you see, it is good to say that, and I understand exactly what you're saying, because contracts are supposed to be dealt with in good faith. But remember that when you are in a contractual relationship, you are in a relationship that has many dynamics. Sometimes it evolves into places you did not anticipate. You may all have the best of intentions going into the arrangement. The beauty about dispute resolution and having an arbitration clause is that you give yourself an opportunity to resolve it when it arises. As an arbitrator, I would say it's a good thing that disputes arise. People test them. They are able to know, and it also helps in future, because disputes also help you to anticipate future conduct. It helps you to also prepare. It gives you precedent. So that, Eric, when you and I have the second contract or third, or you have another contract with somebody else, you can almost tell what will come out of a dispute situation. Contracts are actually improved out of disputes. The more disputes people have. Some people were saying that, you see, we have a very mature electoral system. This electoral system in this country has been modified because of the many disputes we have had. So every cycle is a learning experience. So disputes are not bad in themselves. Even when you hear about political climate, business climate, it doesn't necessarily always mean that those people do not engage in disputes. It means that those people engage in disputes but resolve them in civilized manners. When you listen to the noise in the American political space, it never suggests that people agree. The people don't agree there always. But you'll never see people taking arms against each other. They go to congressional hearings, they go to court, they go to the Supreme Court, and there is a pronouncement on those issues. So human beings are, by their very nature, not created to always agree among themselves. But they must have a place to ventilate, to say what they think, including say what is wrong. You don't have to always be right when you go to a dispute resolution space. So, Eric, to assume that you will have an idealistic situation where people will perform contracts properly without question.
Where people's word is their bond.
It should be that way. It should be that way. But if it does not happen, somebody must come and remind them. And that is where the arbitrator comes
in.
And Kenya has no word.
Well, I hinted on that question then.
Yes.
I mean, obviously there is a push.
Yes.
And it could be, salient or otherwise.
Yes.
There's a push to say Nairobi to be recognized as an international hub for arbitration. Why?
You see, I have always grappled with that question. A hub is not something you impose on yourself or declare, like a republic. It is something that people come to appreciate. The reason why 70 to 80% of disputes are resolved in London, international commercial disputes, is because our reputation has been built over the years. What we need to do as Nairobi is to build a reputation. Our reputation is not built by statutes, by declarations, by presidential, decrees. No. It is built by a culture. One of the things that Eric is talking about. A culture of excellence in terms of the business practices. A culture of excellence in terms of the support structure that comes with dispute resolution. One of them is that you must have competent, qualified arbitrators within that space. There must also be people of high integrity. So these must be people that everybody trusts. And the government must be able to support. You must know that if you come to Nairobi and lodge a dispute in Nairobi, there will be no interference by government, state or non-state actors. If your arbitral award goes to court, the courts understand what arbitration is, what the arbitration outcome is supposed to be, and they enforce the decision of the arbitrator and the rights and obligations of the parties. So a reputation has to be built. But a reputation is also built within an ecosystem that works. So you want to have political stability. You also want to have the infrastructure. Today, the people are big on virtual dispute resolution. So you must have rooms, you must have buildings that are compatible with these processes. You must also have the hotels, the infrastructure, the roads, the airport, direct flights into Nairobi that would allow business people to travel into the country, do their arbitrations and leave. So Nairobi as an international hub for arbitration is an idea which must be nurtured by the state and non-state actors. We play our role, but the state must also play its role. The business community must play its role. The media must play its role. If the image of this country, coming out of this country, is always one of confrontation, violence, if we have always demonstrations on the street, people will say, I will not come to Nairobi to do my arbitration. I will be caught up in demonstrations. We have political instability. Those are some of the things people confront us with when we go out there and we speak about Nairobi and why Nairobi should become a hub. We also need a modern legislation. Today, we have an arbitration act that is 25 years old, 28 years old, actually.
Really?
Yes. it is one of the few legislations that have not been aligned even to the new constitution.
Yeah.
So after the 2010 constitution, many statutes were actually aligned to the constitution. We need a new progressive arbitration act. This is an arbitration act that was there even before the email was the main way of communicating.
Yeah.
So if people come and they look at your infrastructure, statutory, they look at your physical infrastructure, your political setup, they look at the quality of arbitrators you have, and in totality they find that it is acceptable, then they will tell you that, look, you are growing into a hub. A hub simply means that you are attracting more and more within the region, and we must start with the region. So we are doing a lot, but a lot more needs to be done. The setting up of the Nairobi Center for International Arbitration is also a good thing, because it shows that government is committed to having these processes structured.
Recognized and structured.
But it is not enough. The institution itself, that is the NCIA, must be supported. You cannot give it a very small budget and expect that you don't allow it to grow. It does not have personnel, and it does not is not able to carry its weight, and then expect to become a hub.
Sure.
So to become a hub is a conscious decision we must all make, and we must ask ourselves, how do we move there? Then we need leadership in that area. So that is my thinking about the making Nairobi a hub. I will tell you that Rwanda is running faster than we are. They have set up the Kigali International Arbitration Center. It is supported by the government.
Don't go for
Eric,
it.
Let me ask you, I'm saying they are making more effort.
They're making effort.
We
so
are
let me
also
ask
making
you
our own
about,
efforts.
about the
Yes.
efforts. So among the things that you've said, infrastructure, connectivity to the airport, we
Yes.
have
Internet,
we have,
Yes.
do we have competencies? Yes, we have. How many do you have registered?
Over
so far?
1,200.
1,200 plus.
Yes.
Right? Registered and accredited
Yes.
arbitrators in Kenya.
Yes.
We have very many things. Okay, the political climate, it's up and down, but for the bigger part, in the last 8 or so years,
Yes.
it's peaceful.
Absolutely.
Now, the law. What's up with that? I mean, what are you doing as, for example, the chair of the Chartered Institute of
Yes.
Arbitrators and the center itself and others to actually have this law updated?
Absolutely. We are doing everything within our capacity. One of the things we have done, we have approached the Attorney General. We now have a working group, both by private sector and government, to look at our Arbitration Act, to look at the arbitration enabling legislation, to see how we can improve that legislation and have a new Arbitration Act probably in the next 1 or 2 years. Remember that, our legislative processes are also very bureaucratic. It takes time. We are benchmarking with the very best. It is time we moved into a framework that appreciates international arbitration, but with an African touch. One of the things we don't do well as Africans is to develop our own processes. What we do, we cut and paste what we have seen. You're most likely to find that an African country has taken the English Act, put it here, and try to apply it in domestic settings.
Yeah.
The challenge you have with those is that they don't appreciate certain cultural aspects, certain realities that happen. You see, you come to Nairobi, the basic mode of transport is matatu.
Yeah.
You go to London, it is train. So you must appreciate that there are cultural differences. So if you are creating a law, it must be a law that responds to what you do here. So I think, and you look at the business sector in Africa, and particularly Nairobi and Kenya, most traders are informal traders. How can arbitration and these processes actually also respond to their needs? They are not as structured as they are in New York, in Washington, in Paris and other places. So what we want to do is to encourage that the state comes up with legislation together with us, all the stakeholders. We want to sit down and craft an arbitration act that speaks to the needs of Africans in the 21st century Kenya.
Right.
So we are doing our best. We already have a working group. We were just waiting to see the new Attorney General settle in. We will be visiting him very soon to take up. The previous Attorney General had already actually formed the team with us. We hope to move forward that discussion.
Sure.
But the working group does not need the person of the AG to continue working.
Unfortunately, what happens is you have a situation where legislation is actually proposed to the two houses through the Attorney General's
Yes,
office.
that's true.
If you begin work without using or incorporating the Attorney General's office, you will reach somewhere and you will start at point zero once again. So the working group is actually a work in progress.
Okay.
It is already working on these issues.
So it's already sitting down and discussing
we are looking
a draft.
We are looking at a draft. We are looking at collecting views about what we have seen in the previous regime, what we are now seeing as a trend going forward, and what we need to do. So first of all, we must have objectives. We must know what we want to achieve, and then we can now craft something around it.
Do you have timelines for this?
We hope to have a draft presented to Parliament within a year.
Okay.
So do you have so the timelines are within
We
by
do not
the
have
end of this year?
specific timelines.
Why not?
One of the challenges is that we also want to have the working group gazetted, so that it is also supported and it's also structured.
Okay, do you have timelines for that?
We have put our own timelines. I'm not talking about statutory timelines. We think that in the next 2 or 3 months, we should have gotten the nod from the Attorney General, have the working group or the task force gazetted with terms of reference, and then we have a time frame within which we will deliver the first draft or a report. That is the thinking.
Okay.
Yes.
How is this all funded? Is this funded? So, one is, do parties pay a fee as they come
To arbitration.
to arbitration? How else does support come? Because obviously arbitrators are paid. The center must run, keep the vehicle going.
Yes.
So how does that all come about?
There are 3 areas on funding of this process. Number one, when you request for appointment of an arbitrator, you pay a very modest fee. At the institute, you pay 20,000 shillings. And then you get an arbitrator appointed. So those are some of the fees we collect and run the center with. The second revenue stream we have is training. We train arbitrators and they pay some fees for the training.
Okay.
Thirdly, and which I think is what you are interested in, is how do arbitrators get remunerated? Arbitrators are paid by the parties. Parties pay an equal amount. Arbitrators are at several levels. We have the very basic, an associate, a member level, fellow, and a chartered arbitrator at the highest. So a chartered arbitrator would charge you, for instance, 30,000 shillings an hour. So each party will pay 15,000 shillings until the matter is determined, and then the arbitrator will decide who bears the costs at the end of the day. Now, another area where we make some money from is we have activities, we have cocktails, we have conferences, we have webinars, we have symposia, which we use to continuously develop the skills of our members. So those are some of the areas in which we try to get. But the center runs on membership subscriptions. Membership subscriptions, you are a member of the institute, you pay a very modest fee, a yearly fee of about 10,000 shillings, 7,000 shillings. That is what keeps us running.
You're a lawyer.
Yes, I am.
What's the term that the Law Society uses to determine how much a lawyer should be paid?
The remuneration.
That one.
Yes.
What's it? Say it again in full.
Remuneration.
The remuneration something.
It's like fees.
Yes.
Yeah.
So it's set.
And a remuneration order.
The remuneration order that
Yes.
is set by the LSK.
Yes.
Same thing happens with doctors.
Yes.
There is, a scale
A scale, yes.
by which you pay.
Yes.
Do you have the same for arbitrators?
We have guidelines. We don't call it a remuneration order. We have a guideline set, published, reviewed every 3 years. We send it out to members and members of the public. It is accessible on our website. It gives you an idea of how much you will pay. It is usually an hourly rate. The lawyer's one is a percentum of the subject matter. Ours is an hourly rate. It's actually more cheaper than hiring a lawyer, because a lawyer will charge you 4-5%, 3-4-5% of the subject matter. Assuming it's 1 billion shillings, you can calculate.
Yep.
An arbitrator will charge you for the actual hours spent dealing with your matter. So it is an hourly rate starting from 7,500 shillings all the way to 30,000 shillings per hour. So yes, we have those guidelines.
Okay.
Yes.
What does it take to become an arbitrator?
This is a question I'm asked, and surprisingly, it is one of the easiest things to do. Many people, when they come before us, they are in awe. They believe that we are grandmasters of something. It is actually a very simple thing.
Yes.
It is so simple, it will surprise you, Andu. It will really surprise you that the initial course, the associate member course, takes 2 days. 2 days of your entire year. 2 days. And you sit a multiple, what is it called? A multiple choice exam. 60. I'm sure the last time you heard of this is in primary school.
Yeah.
That's what we give you. And at the Chartered Institute here, by the way, our branch has the highest number of qualified tutors anywhere in the globe, including more than the ones in London. And our pass rate in the associate course is 99.9%.
Everybody passes.
Are you serious?
It's multiple choice.
90.
No.
Because of that. It is credit to our preparation of the candidates also, because that course is offered elsewhere, and the pass rate is not as good. So it is so easy. So that is the first level. Then the second level is module 1, there's module 2 and module 3. It gets a bit, I don't want to say harder, it gets a bit stricter as you go up. Module 1, we teach you the basics of law, because remember, not all arbitrators are lawyers. In fact, arbitration is an effort to avoid legalistic dispute resolution. So Eric, you are a journalist and you want to become an arbitrator. We will give you on module 1 some basics of the law. So we'll teach you some contract law, some law of tort, then progress you to module 2. In module 2, we will teach you the practice of arbitration itself, how to receive evidence, how to treat parties equally, fairly, how to be an impartial adjudicator of disputes, an arbiter, how to receive evidence, how to consider evidence. Very basic. And then in module 3, we will teach you the aspects of writing the award or the decision of the arbitrator. And then we'll take you through some level of oral exams just to find out how you are faring. It's really a skill-based training. It's supposed to be skill-based, hands-on, practical training. Then we give you mentorship. We are the only professional organization in this country that you do not look for internship, like people drop CVs here.
Yeah.
What we don't do that. What you do is that after you finish your module 1, we write you an email. If you request, we write you an email and tell you, go and sit with Dr. Mutubwa in these 3 arbitrations and come back. When you come back, we'll appoint you.
Right.
So we are one of the few bodies, and I tell this even to the president of the Law Society, that look, we are one of the few bodies where people do not look for interns or internship. We have about 20,000 lawyers, but we are not able to get pupillage places for about 2,000 trainees.
For new trainees.
2,000. It just means that for every 3 lawyers, you just need to say that you will take 1 intern. And sometimes it becomes a difficulty. We have done it ourselves. In fact, today when I look at my records, we have more mentors than we have mentees. We are looking for people to come and take up mentorship. So, Eric, if you started your journey now of becoming an arbitrator, within 2 years, you will have achieved the highest level if you want to.
So within 2 years, you can become a chartered arbitrator.
Depending on how you move. Chartered arbitrator, between fellow and chartered arbitrator is a matter of experience.
Okay.
So you will most likely become a fellow.
Okay.
And that is sufficient. It's the highest level.
Is the training part-time or full-time?
It is not full-time. It's a modular training, meaning that we set dates. There's a calendar throughout the year. You may take your first course in April, take the next one in September, depending on your flexibility. Some of the courses which take 3 days, we split them. We can have 1 day this month, another day next month, and a third day the month after. We give you the material, we train you, we give you tutorials. They are both online and in person. It's very flexible.
Virtual, physical?
Virtual and flexible, sometimes hybrid. We train many people who are not able to even travel into Nairobi. Some people join us even from Sudan. Some people join us from Egypt, wherever you are. It takes just you to structure yourself.
Okay.
It is so easy that it is so surprising that I always encourage many people to take this as a second profession. You could also contribute to your profession by resolving disputes. We have engineers who practice engineering, but they can resolve disputes on other roads. or other buildings which they are not involved in terms of the project.
Yeah.
So it is so easy that sometimes I get surprised when people ask me, how have you achieved all this?
What have you done?
There is really
How does
not
one
much.
get in touch with the institute?
The institute has a website. You just go to the website. You will find.
So if you Google the Chartered Institute of
Chartered Institute
Arbitrators,
of
Kenya,
Arbitrators Kenya, you will see our website. It's very easy to navigate.
and the contacts are
You
there
can
as well.
apply there, make payment. The contacts are there. We have people who are present all the time to answer your questions. I am also available anytime. to
Let's
respond.
do this thing.
Yes.
We'll do this thing.
Welcome.
Daktari,
I hope
thank
to see
you very much for joining
Asante
us.
sana.
Dr. Wilfred Mutubwa is chairman of the Chartered Institute of Arbitrators Kenya branch. We want to make Nairobi the preferred seat for alternative dispute resolution and international arbitration.